I'm sorry, I'm getting high strong again. But I love the Constitution. I'm talking about the enactment clause under our Constitution.
Okay.
Michigan Constitution, 1963, Article 4, subsection 23.
This guy right here is Dale Morris, a double bank robber who's about to put the judge in an uncomfortable situation.
16 years I've been on the bench and never bent the Constitution in any direction.
Okay.
Dale Lester Morris, 53, was often confrontational during his court proceedings. However, after being found guilty on April 19th, he simply said, "See you later," to his standby counsel as he left the Washtenaw County Trial Court. Morris had vigorously fought charges of bank robbery while representing himself. He claimed that his arrest in Kansas violated court procedures, argued that the law against bank robbery was invalid, and pointed out discrepancies in his identification. He was accused of robbing the Bank of Ann Arbor on July 8, 2015 while wearing a fedora, and robbing Eastern Michigan University Financial on July 9, 2015 while wearing a baseball hat and pantyhose on his head.
I'm talking about the enactment clause under our Constitution.
Okay.
Michigan Constitution, 1963, Article 4, subsection 23. What it states, it's mandatory, it's shall. You know this.
Mr. Rory?
Okay, I'm sorry, I'm getting high strong again. But I love the Constitution.
Take it down, take it down. But no, I didn't know. I mean, I know I schooled you on it, but I didn't know you'd then go and listen to me.
Morris requested a mistrial from Judge Archie Brown at the Washtenaw County Trial Court. He claimed he didn't receive evidence before the trial, citing issues with the Michigan Department of Corrections. However, Assistant Prosecutor Brenda Taylor contradicted his claims, stating that Morris had been provided with evidence before.
That you have violated this statute that the state of Michigan, or the people of the state of Michigan have enacted. So you got that just a touch bit wrong.
Okay, correct.
All right.
But it should say enactment clause, because this lets me know the authority by which is decreed.
It doesn't have to. But go ahead.
It doesn't have to, but Your Honor, I'm not even in no position to say anything. You know the law, but I'm just saying from what I'm reading in the Constitution and what it says and what Supreme Court justices have stated on the matter.
All right.
Okay? That's all I'm saying. I don't know nothing but what I read and what I interpret. I think I'm pretty intelligent enough to interpret the English dictionary.
Yes. Yes. All right.
During his closing argument, Morris argued that the witnesses who identified him as the bank robber gave inconsistent descriptions that didn't match him. He also pointed out that fingerprinting and DNA testing were not done.
In 16 years I've been on the bench and never bent the Constitution in any direction.
Okay.
So if that's meant as some sort of pejorative word that I want to try to fashion something to fit where I want to be on it, I'm not going to do that. I will interpret the Constitution. I will interpret it based upon precedent. I will interpret it based upon the plain language that's contained within the statute.
Could you tell me what the plain language?
I don't bend anything.
All right.
Bank tellers from both banks testified that Morris handed them notes demanding money. Shayna Sondok triggered the silent alarm and gave him $1,077, while Jasmine Chapman Lewis gave him approximately $6,000. The prosecutor, Taylor, acknowledged that witnesses were in a heightened state, but emphasized that they separately identified Morris from surveillance images. He outsmarted the judge, but only for the judge to consider a heavier sentence. Meet prosecutor Mark Sleeper. During the court trial, he decided he'd had enough of Judge Walliver when they argued about continuing the trial without prosecutor Melissa Schiffel. Tensions escalated in a court proceeding in Delaware County, Ohio, when a prosecutor accused the judge of conducting a sham trial and stormed out of the courtroom in anger. The trial was focused on Matthew Moore, who is accused of killing his late wife Emily Noble and making it look like a suicide. Noble was reported missing in late May 2020, and a body was found 4 months later hanging from a tree near her home. Medical examiners determined that Emily Noble's cause of death was strangulation, and the autopsy report revealed multiple injuries around her neck and face. Investigators concluded that her death was a homicide, and prosecutors have accused Matthew Moore of killing her and making it look like a suicide.
No, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiffel...
Your objection is noted.
Attorneys Melissa Schiffel and Mark Sleeper represented the state in the Noble case, with Judge Stephen Walliver presiding. On the trial's seventh day, Sleeper objected to the proceedings proceeding without Schiffel, who had previously informed the court that she couldn't attend due to a scheduling conflict. However, Judge Walliver stated that she had chosen not to be here.
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what, if you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
During the trial, there was a tense moment when Sleeper objected, claiming that the proceedings were inaccurate. The judge sternly acknowledged the objection, but Sleeper reminded him of a conference held 2 weeks prior where Schiffel had mentioned her scheduling conflict. In a strong statement, Sleeper announced he wouldn't take part in the proceeding, expressing his belief that it was a sham to move forward without the absent prosecutor. He accused the judge of being informed about her unavailability and even encouraging her not to cancel the appointment. The judge responded nonchalantly, stating that if Sleeper didn't want to be present for the decision, it was his choice. Sleeper didn't back down, stating his outrage at the trial proceeding without the prosecutor. With that, Sleeper turned his back on the judge and left the courtroom.
I have prepared my remarks and my decision here today